Get ready. 3 seconds. 2 seconds. Start. This is yet another case where a young bride was sacrificed at the altar of dowry. Full stop. An educated lady was given in marriage to accused appellant. Full stop. The marriage was solemnized on 13th March, 1991. Full stop. Both the parties were Hindu, and according to their customs and belief, marriage ceremony is a sacred and solemn occasion where the bridegroom accepts the bride as his wife, assuring her protection for the whole life. Full stop. Although there is no scope to look for worldly consideration on such occasion, the other accused appellant, brother of the bridegroom, however, insisted at the time of marriage that unless a color TV is provided along with the bride, she is not acceptable to them, and the marriage cannot be solemnized. Full stop. Placed in such situation, the family members of the bride, however, managed a black and white portable TV and assured better one, after the marriage. Full stop. The marriage ceremony was thereafter solemnized, and the young bride went to the husband's place, but there was no end to her miseries. She was abused and touted for not bringing quality as well as quantity dowry, and on 6th October 1992, on the day of Vijaya Dashami, when as per Hindu mythology the goodness scores victory over evil, the young bride of 1.5 years old marriage suffered burn injuries to the extent of 95% at her matrimonial house. Full stop. She was moved to a hospital where she succumbed to the injuries, thereby putting an end to all her miseries in this worldly life. Full stop. Para. In the present case, there is overwhelming evidence on record to show that victim died as a result of burn injuries sustained by her in the house of her husband on 6/10/1992. Full stop. PW9, doctor and assistant professor of forensic medicine, Medical College Hospital, who held the autopsy over the dead body, found dermo-epidermal burn injury present on the whole except parietal areas of both sides of the scalp and the peritoneum. Full stop. The burn injury was about 95%. Full stop. Para. Learned counsel for the appellant has submitted that in the present case there is no evidence to draw presumption under section 113A/113B of the Evidence Act, as the prosecution has failed to establish that soon before her death the deceased was subjected to cruelty or harassment by the appellants in connection with any demand or dowry. Full stop. In support of the above submission, the appellants have placed reliance on a decision of the apex court in the case of Samlal versus State of Haryana 1997, 9 SCC 759, AIR 1997, SC 1873, Police Stop, Para. Admittedly, there is no eyewitness to depose as to how the young lady was set on fire. Police Stop. The occurrence took place in the house of the accused appellant, and as such presence of other witnesses at the relevant time is not expected. Police Stop. The only eyewitness was the victim, who is dead and gone. Police Stop. In the absence of any such evidence, it is not permissible to take recourse to the legal presumption envisaged in section 113B of the Evidence Act. Full stop. Para. On judging the evidence and circumstances of the case, it is seen that the motive for gruesome murder was that the deceased, who did not bring sufficient dowry, may be eliminated and replaced by another young woman along with more dowry. Full stop. There is clear and cogent evidence in this regard, and there is absolutely no reason to doubt the same. Full stop. Therefore, the prosecution has established that the appellants have committed an offense punishable under section 304B IPC beyond all reasonable doubt. Full stop. There is no merit in this appeal, and accordingly this appeal is dismissed.